Good morning. Hi, I'm Jim Crawford, and welcome to the James E. Crawford Jr. and Associates Law Firm. I want to talk today about an issue that I think could be important to a lot of different people. I want to talk about the charging process, how people are actually charged in the state of Maryland, and what you should do if you or someone is actually charged. Now, we're talking about a wide variety of different types of charges. They can range from simple traffic offenses, such as driving on suspended, driving on a revoked license, which is a misdemeanor, minor type crime, all the way up to felony murder type issues, or even sex offense issues, robbery, etc., etc. When someone is charged with a crime, there's several ways that can happen. The first way is a very simple way, been around forever, and that is basically one individual can walk up to a commissioner. A commissioner is not a judge, it's a judicial officer, usually located in the district court in the county upon which you reside, sometimes in the police state, sometimes police station, sometimes in other municipal county buildings. Go to the commissioner. At the commissioner's office, that individual will write out a statement of facts that is indicating what happened. So if we're talking about something like an assault, second degree assault, first degree assault, the commissioner will review what happened, what's written down. The person signs it under oath, and the commissioner's job is to make the determination as to whether or not there is a crime that has occurred. If that's the case, the commissioner's job next is to simply determine whether or not a summons will be issued or whether or not a warrant will be issued. If it's a summons, you will receive a notice in the mail, and it will be a situation you get a trial date. The trial date could vary from county to county. Baltimore County is pretty quick. Analog County is pretty quick. Hartford County is sometimes quick. Baltimore City a little bit slower depending upon the type of case. So if it's a summons, very simple, do what you need to do. Now, if you are issued a bench warrant, in other words, if the commissioner says, you know what, I'm going to issue a bench warrant in this situation, then things change. And what happens is that the police will come lock you up. Sometimes there's situations where my office and what a lawyer can do sometimes is say, hey, file a motion with the court to try to quash the warrant. That's a totally different issue. But normally the person is arrested. Once the person is arrested, okay, what occurs is they're taken before a commissioner. The Maryland rules say 24 hours. It doesn't always happen that way. For years and years and years, it didn't happen that way. Baltimore City years ago, there was a problem where people were actually kind of getting lost in central booking. It used to be called the Baltimore City Detention Center or Baltimore City Jail. It's now central booking, has been for a good while. But people got lost and sat in there for a long period of time without even seeing a commissioner. Well, Judge Cooksey was a judge in Baltimore City, great judge, years ago, instituted a study. And the bottom line is that it works better now. It's still not quick in Baltimore City. It's quicker in other counties. Baltimore County, depending upon what day or night it is, if it's busy or not, it can be really, really quick. Haverford County, Howard County, the same thing. But once the commissioner sees that person, the commissioner makes the determination whether or not bail will be issued. Now, the key here at this point in time is determining whether or not you're going to pull the trigger and accept that bail. So, for example, if the commissioner says, you know what, this is an assault case. It's a very serious assault case. It's first degree assault, not second degree assault. I'm going to set a bail for $500,000. Well, most people may say, you know what, that's crazy. I can't do that. I'm going to wait to see what a judge does. Because in Maryland, you have the absolute right to then, after commissioner, go before the judge the following day or that day, depending upon what's the next available slot. The key here, again, is basically determining and knowing what that judge could do. So you may think $500,000 is high. Well, a judge may, in that particular situation, set it for much higher or maybe no bail. Possibly could lower it. Depends, again, on the personality and the knowledge of what that judge sometimes will do and not do. So it's very, very important that you have someone that's been there and can kind of advise you about what to do in that scenario. The difficult thing is that in these situations, a lot of times, these things happen in the middle of the night. They happen at 12 o'clock at night, at 4 o'clock in the morning, and it's tough to get a lawyer on the line to make a decision. You got to try. Now, you can call our hotline. We have a hotline, 443-829-1446. And sometimes, we don't pick up immediately. We'll get right back to you because people are sleeping and what have you. But we do, and we will get back to you. But it's very important that you understand this is something that needs to be taken care of, because if you make the mistake and don't pull the trigger correctly, then that person could be sitting in jail waiting for their trial for weeks or months down the road. It could destroy lives. Jobs are lost. Families are forgotten from the standpoint, money's coming in. It's a big, big issue in that situation. Okay, the last thing I want to say basically is, or the third method is, that a person could be charged via indictment, criminal indictment. That means a grand jury, 24 individuals from the voter registration polls will sit and listen to a state's attorney um, indicate what a particular crime was. Now, it's very interesting because grand juries are an actual constitutional right and a constitutional method in the Maryland Constitution and the United States Constitution. They differ, the federal courts differ, but state is very similar. And it's a confidential issue. In other words, if you are the target of a grand jury investigation in the state of Maryland, you do not have the ability to go and watch. Okay, there's some things you can do. You can make motions if you know it's going to happen, ask that it be recorded, etc. But generally, there are rules and there are basic issues with even trying to pierce the grand jury issue or grand jury privilege. So what will happen is the state's attorney will go in there and they'll say to the juror, grand jury, say, listen, here's the facts. You bring a police officer and you say, we think this happened, that happened. They say, okay, raise your hand. Who believes that this person should be indicted? You get a raise of hands. Most of the time, most people say, yes, we believe, and then a criminal indictment is issued, stamped, and there you go. You're now officially charged, and you go through the process of being arrested, etc. So obviously there's more to the story and more things to think about, but those are the three basic methods. If you get anything out of this little discussion and talk, remember, it's so important, those first 24 hours, about what you do with bail and don't do with bail, because it could affect how the trial proceeds. If someone's locked up in the detention center, it's very difficult to prepare for trial as opposed to be able to come to a lawyer's office. People can go to work and do what they need to do. So make sure you have something on hand. Have my number or someone in my office, or at least a lawyer's number. We have a bail bondsman I've used for 25 years. Mike, he's great, and he does exactly what we need him to do. There's plenty of bondsmen out there, but I would always recommend him because he's somebody that's been very loyal and somebody that takes care of business when it needs to be taken care of. Anyway, I hope this helped. I'm Jim Crawford. Thank you very much.